Thank you. I'm glad to be back. It feels like I rarely have a paper that feels appropriate for this conference, and so I'm happy that I had one that feels right and that the timing is right this time around. So I could come out. And moreover, this is something of a departure from what I do in general, of being what I think somebody earlier referred to as sort of applied originalism, which at one point in my career I thought I'd spend a lot of time doing. But my historical outlets have tended to be less focused on when meaning is fixed and more focused on when meaning is not particularly fixed. And this paper's also sort of been in the back of my mind in some ways for a long time. So my dissertation advisor was Roger Smith, who was probably one of the original revisionists on this particular topic, having written a book with Peter Shook in the 1980s, advocating for what I hear characterized as the revisionist view about birthright citizenship. I wasn't particularly persuaded by Roger's views then, and I remain unpersuaded, but I didn't think to write about it until now, when suddenly it seemed more pressing and interesting to engage with. For what it's worth, Rogers continues to think I'm wrong on this, but you know, what can you do? Your dissertation advisor sometimes makes mistakes in all kinds of ways. This paper is not concerned with everything that the Trump executive orders potentially raised, but it's concerned with trying to puzzle out one particular issue that is quite relevant to that. And really, it's an issue that I was prodded to engage in by the work that Barnett and Moorman have done lately on this. And pressing on this question of traditionally, as we've understood, the idea of birthright citizenship as it emerged out of the English common law, as it was applied in American law, as it's embodied in the 14th Amendment, we recognize that there's some kind of default about people born inside the United States as having birthright citizenship, and that the subject of the jurisdiction language in the 14th Amendment also embodies what we or at least in part, embodies what was also traditionally recognized as what's frequently characterized as exceptions to that general rule that existed in the English common law and continues to exist now. And so part of what I take Barnett and Moorman is pressing on is that question of are those exceptions really just ad hoc carve-outs? Is there some kind of principled logic to understanding those exceptions? And if so, how does the principled logic of the exceptions fit with the principled logic of the core birthright citizenship rule? And to the extent that there's either principled logic there or these are just ad hoc carve-outs, might there be more potential exceptions beyond the sort of traditional ones that people were primarily thinking of prior to the adoption of the 14th Amendment, for example, such that that might be particularly relevant in the context of modern immigration law, which of course imposes all kinds of restrictions on immigration that didn't exist at the time the 14th Amendment was being drafted and ratified, and so places these kinds of rules in a very different legal context than they might have been before. So the paper is essentially concerned with trying to tease out the principle of birthright citizenship, tease out the logic of the exceptions, so-called, to birthright citizenship, as I had an exchange with Elon the other day at the Federalist Society event, and I think he appropriately objects to the language of exceptions in this context. It's the traditional way of talking about them, but I think he's right that we shouldn't think about these so much as exceptions as really, I tend to think of them more as scope conditions, that they are clarifying where the boundaries are of birthright citizenship. And the traditional common law rule relative to those boundaries is that the logic of birthright citizenship did not extend in cases of foreign ambassadors and children of foreign ambassadors born on the sovereign soil, and likewise did not apply to invading armies. And so if invaders had children on your soil, their children would not be natural-born citizens or subjects either. And of course, in the American context, the subject jurisdiction language and the debate surrounding it in Congress is centrally concerned with what to do about Native American tribes in particular, which is not a category that was particularly relevant to the English common law or even to earlier American debates surrounding this, but were extremely relevant as they're thinking about how to embody a rule like this into the constitutional text and to ensure that the language of that textual rule is not more sweeping than they really intended, and from their perspective, making it so sweeping that it would include everyone born within fairly independent tribal sovereigns would be too sweeping. And so subject jurisdiction debates are filled with discussions about the implications for those tribes. I think the logic of that sort of new exception in that sense, though, is actually a continuation of the same logic as the earlier recognized exceptions. And likewise, then, the language of subject jurisdiction easily captures all three of those kinds of exceptions, as well as some other marginal cases we might imagine as well. That is to say that they're all concerned with what the scope of the governing authority is of the nation, who's within the scope of that governing authority. If you are within the scope of the governing authority, and even if you're an alien, if you give birth to a child within that territory and governing authority, that child is then a natural-born subject, or in our case, a natural-born citizen. But on the other hand, if you are not subject to governing authority, and the claim is that foreign invading armies or foreign ministers or ambassadors, and likewise self-governing Native American tribes are outside the scope of the relevant authority. They're not being governed by the sovereign authority, and as a consequence, any children born to them exist outside the dominion of the sovereign, even though they might be on the physical territory within the geographic scope of the sovereign's claims. So in our case, they're born within the territory of the United States, but they're not born within the governing authority of the United States. It's obviously quite rare that anyone would fall within these categories. One reason why the exceptions were frequently recognized but not really elaborated on or emphasized very much, because these are unusual circumstances that would lead to these. But there is an interesting underlying logic and set of principles associated with them. And I think one implication of sort of thinking through the logic and implication of those underlying principles is it's highly inappropriate to extend those to the context of unauthorized aliens, undocumented aliens, illegal aliens, however you want to characterize them, inside the United States. They don't have that same crucial characteristic of being outside the governing authority of the United States. The children born of people in those circumstances are born within the territory of the United States, and moreover, they're born within the governing authority of the United States. And as a consequence, their children are in the same situation as any other children born of aliens within the United States might be, which is to say that under the terms of the 14th Amendment, they are natural-born citizens. I'll just note briefly that the paper itself tries to do a couple things relative to that, besides just sort of unpacking this larger set of principles and understandings as it was carried into the mid-19th century United States. One is to think about the extent to which the 14th Amendment was motivated by and was concerned with responding to Dred Scott and a set of arguments that had emerged among pro-slavery forces in the late antebellum period about citizenship and natural-born citizenship rules that the 14th Amendment was designed to set aside, which had implications not only for race, but also for thinking about political control over who could be citizens or not. And it's an central concern of the 14th Amendment is to take this outside the scope of political authority more generally. And I'll leave it at that. And so happy to hear the conversation relating to this.
going to start with an observation and a confession. My observation was this was not the paper I thought Keith Whittington would be writing, because as you know, Keith is a sort of a beautiful theorist about fixed meanings and the method of originalism, and this is more of an applied originalism topic. The other thing I didn't know was that Roger Smith was your dissertation advisor, because I had sort of given a preview of this, my own work on this topic, and Roger Smith commented on it, and he seemed to like it more than he likes your argument, or at least that was the impression. So, and that's the lead up to the confession. I have a pony in this race. I have a different theory of the citizenship clause, but it's not the one that Barnett and Werman make, which sort of targets the unlawful aliens. And I have to say, Keith, I'm 99% in agreement with you that that actually is not a valid reading of the citizenship clause. I want to focus on the temporary sojourners piece, that is, the people who are in the United States that are not residents. And I just want to, I'm breaking the norm with slides, and the paper is a work in progress, hopefully, but I didn't want to inflict it upon you guys because you already have so much to read. And a couple of the key words are in red. The words "or naturalized," which people often forget about, are part of that clause of the 28 words in the clause, and then the word reside. And that word is forgotten because in slaughterhouse cases, Justice Miller suggested that state wherein they reside, that just goes to reside in terms of the state. But you could sort of say it's an implied presupposition that whoever actually the amendment applies to actually resides in the United States, right? So my theory is temporary sojourners are out because if you're a birth tourist, you don't live in the United States, and so that's too incidental or an accidental relationship for you to actually be covered by the citizenship clause. Very interesting. Or naturalized was introduced very late in the process by Pitt Fessenden, the senator from Maine, who was sort of a well-respected figure but didn't say much. But when he said something, it was sort of like George Washington at the convention. People listened, and he was a very powerful force, and he's the one who put it out there. And I submit that that phrase changes the meaning of the citizenship clause, including its birthright prong. It's the naturalization prong, and expanded its original meaning beyond overruling the 1857 decision in Dred Scott. It's talking to a different type of controversy, and the controversy was the international citizenship controversies at the time. The age of steam travel had enabled much larger inflows and outflows of population. You had people coming to the United States, giving it a shot, going back. You had a situation where you had very, very fluctuating concepts of citizenship. The wars were going on in Europe. You had Prussians trying to draft people. You had Great Britain trying to draft people. You had the French trying to draft people who were dueling claims. And you see the State Department dealing with this issue over and over again. And my basic idea is, well, you know, if you're a temporary sojourner, and this is a great piece of Keith's paper, the sovereign owes you a duty of protection. But if you're one of these international people, that duty of protection is an international duty. So why exactly would the citizenship clause create that duty to attach to somebody who's the child of sojourners, where the expectation is that they're going to return back to their country of origin? So that's sort of my affirmative theory in a nutshell. And I'm going to go through my thoughts on Keith. Keith says that this was the common law theory, and I do believe that Keith is correct on that, and he does a terrific job of spelling out Blackstone on the point. But the common law itself was adopted from the law of nations, and so I think there's a situation, and I think Keith correctly reads the dissent in Wong Kim Ark. One interesting aspect of all of this is the extent to which Wong Kim Ark is in the background of everything that Keith writes about in our understandings, because I think that the by birthright citizenship, we're pretty much assuming that Justice Gray's opinion for the majority in 1898 was an adequate capture of what was going on in 1868. And I actually don't think that's right. I think that Justice Gray wrote an extremely erudite, powerful opinion, but he created a reality that was very different from the reality with regards to citizenship in 1868. They needed manpower. They had lost, hundreds of thousands of men. They wanted to bring people over. They had this problem of conflicting loyalties. In 1898, the United States was on the cusp of empire. They wanted to have people come in, but at the same time, they didn't want sojourners out because that would create friction with the countries in which they would return to, because the United States owed a duty of protection once they had returned. So in any event, one aspect is it really from common law or is it the law of nations? And if it's really from the law of nations, why shouldn't we look at the law of nations in 1868? And the treatises, it's very interesting because the treatise that was most widely read at the time was by General Halleck. I think those of you who are Civil War buffs probably know who General Halleck was. He was a Union general, but he wrote a very interesting international law treatise in May of 1861, and he goes into these details in depth. And one of the points, for example, is, okay, so the children of foreign ambassadors and ministers are not citizens. What about the children of foreign consuls, right? And the authorities were divided because foreign consuls, those of you who do international law know, they have a different status. They have a different treaty under international law. They're commercial representatives, and so the authorities are divided. Some people say, and in many instances, the consuls of foreign countries were actually U.S. persons, like Frederick B., consul for China in San Francisco, very, very famous consul. And so, yeah, the authorities are divided on that. And so that's just to show you that it's really the law of nations that's doing the work here, not necessarily common law. Common law had absorbed the rules. The other aspect of that was, and Keith talks about this, he talks about how there were 3 common law rules relating to citizenship, and the United States adopted the birthright piece. The other 2 he calls the law of election, and the other is sort of the law of expatriation. And what do those mean? So there's a debate between the United States and Great Britain about when exactly natural-born citizens of Great Britain become citizens of the United States. The U.S. position is July 4th, 1776, because Declaration of Independence. And at the time, under international law, the position was if you have a fragment of another sovereign state and they actually become independent, it requires the reciprocal consent of the other sovereign. So the British position was, no, no, no. The date is April 1783. And this was a real difference of opinion. The way the United States thought about this was they actually, in the late 19th century sources, they talk about something called collective naturalization. Because the idea is this is a process by which natural-born subjects of Great Britain became citizens of the United States, and it's a collective naturalization. So that concept works itself out in other treaties at the time, too. So I think that's also relevant. The final, I see I have 2 minutes, and I've been talking extra fast. So they rejected the common law rule regarding election, is what Keith called it. I call it collective naturalization. They also rejected the British common law rule about expatriation. So the British common law rule was once a subject, always a subject, perpetual allegiance until the king let you loose. So in 1868, the same 39th Congress that ratified the 14th Amendment passed something called the Expatriation Act. And they said, look, no, that's not true. If a person wants to cast off their sovereignty, and this is because of the international citizenship controversies that they have with, primarily with France, Britain, and the German states, they weren't quite unified yet. They say you could do it unilaterally, and that was the exact same Congress that ratified the 14th Amendment. So they've rejected 2 of the British common law rules. Why is it necessarily the case that they kept the 3rd one without any amendment or any alteration to the circumstances? So I think they mostly kept the British common law rule, but they didn't intend sojourners to be brought into it. So that's my point about common law and law of nations. The last point is just the theory of citizenship, right? I agree that the idea that you had to be politically subject to the jurisdiction is too thick a link. But just because you're born there is too thin a link. The idea that if you're here as a birth tourist, that's the idea that that's too thin a link, but if you're here as a resident and you could be here on a student visa or whatever, but your parents are here to reside. And that seems to me a much more coherent theory of citizenship. So in any event, these are slides that spell that out, and I hit 10 minutes on the dot.
I think that's clearly correct that there are connections between how citizenship and is being worked out locally within individual countries, and also how it's being worked out internationally, including sometimes through explicit treaties and sometimes through the law of nations. There's obvious problems and concerns if you have multiple sovereigns disagreeing about who actually counts as a citizen for various purposes, and thus you get British impressment, for example, into British naval service that partially was being driven by arguments about who really is an American, and as a consequence can and can't be impressed into British naval service at various points. So there's clearly connections between the two things, and there are efforts, including in treaties that the United States enters into in the period between the founding and the Civil War, that tries to address and clarify some of these issues, including using the language of subject to the jurisdiction in order to try to work out how the United States is going to treat these things relative to other countries. So I think that's right. There are certainly connections between the two. I just don't think there's much evidence to suggest that the Americans abandoned the common law, nor is there much evidence in the 14th Amendment context that they were thinking about this primarily in law of nations terms rather than common law terms, particularly although there's substantial overlap. Likewise, I agree, of course, that as I say in the paper, that the Americans rejected two core components of how the British thought about this, both relating to the right of election and the expatriation problem. Both of those were moves they made fairly early on. I don't think they have lots of implications for suggesting that they were significantly modifying other features of the common law understandings. And again, I don't think there's much evidence from this period that suggests that they were doing so. And so I think these were parts of the common law inheritance that could be shed and were effectively shed, but without necessarily doing any real damage or principled violence to the components that they kept. The temporary sojourn question I actually do find to be somewhat challenging in this sense. I think that the logic here is relatively straightforward about what the implications of the rule are for people who find themselves as temporary sojourners. It is nonetheless the case, though, that there's not a lot of discussion of it in the American context in general prior to the Civil War. There's not much discussion of it in the context of the drafting and ratification of the 14th Amendment specifically. It's just not a problem they thought very much about. And so to the extent that they might have embraced some idea of a carve-out, it's not something I think they left as much information with one way or another. And so then you're just sort of left, I think, to think through the implications of first principles, and I think the implication is that temporary sojourners, generally speaking, ought to be qualified, which is not to say that that's the best policy one might want to adopt. Moreover, I should emphasize as well, it's not to say the federal government then is without capacity to address this problem. If the federal government has concerns about birth tourists, there's lots of policies you can adopt to try to discourage and minimize how many birth tourists you wind up having or how many temporary sojourners you find yourself with who wind up having children while they're inside the United States without questioning the core commitment to birthright citizenship as such. And I have no strong views about what the policies ought to be on those questions. My concern is simply that we shouldn't do violence to our Constitution in the process of trying to adjust to some policy preferences people currently have.
I have about a dozen questions, but I'm going to ask two, though maybe on the temporary sojourner point, another interesting just data point for Tom's thesis is in 1863 and 1865, the Union authorities were debating whether they could conscript the children born in Louisiana of French parents, and they concluded they could not. And they thought they were applying something, like maybe the common law, but those aren't my questions, though. So.
Just a quick addendum. The Enrollment Act did conscript non-citizens. It was just Louisiana. Yeah.
So the questions I have about the common law rule, in particular, the question of unlawful status. And so it's two related questions. The first is, you know, in your paper, you talk about the rule being birth alone, birth alone, birth alone. What do you do with all the sources that say actually the rule was being born to parents who were under the sovereign's protection? So this is what Cook says in Calvin's case, right? Why are invading armies not a child born to an invading army not covered? Because although born on the king's soil, that child is not born under the ligeance of a subject or under the protection of the king. In other words, he says, you have to be born to someone who is a subject of the king. And an alien could be a subject, right? If you had exchanged this local and temporary allegiance. Blackstone explains the exception for ambassadors. The representation of the child is the sovereign is represented by the father, the ambassador. Story says nothing is better settled at the common law than the doctrine that the children, even of aliens born of parents resident in the country and under the government's protection, is a citizen, right? It's the parents that modifies it. So I suppose, and Bingham says this, and some of your sources say this. So I guess my question is, do you have any historical example or evidence of a child born in the realm being under the sovereign's protection when the parent was not, for whatever reason? I know of no such example, but maybe you have, or maybe you think it's not relevant for some other reason. And then the second is a related question. If the test is whether the sovereign, or if the test is whether the parents have to be under the sovereign's protection, what do you do with all the safe conducts and the statutes, including the statute of 1353 in the reign of Edward III, that expressly grants not only permission to enter the realm, but extends the sovereign's protection? So Magna Carta grants aliens from friendly countries safe and secure conduct unless they have been previously or publicly forbidden. That's the 1297 version. Statute of 1353 says alien merchant strangers may safely and surely and under our protection come and dwell in our said realm. Now, none of that proves that without a safe conduct and contrary to the laws, somebody would not have been under, an alien would not have been under the sovereign's protection. I can't prove that. The Magna Carta gets pretty close, right, when it says unless they've been previously and publicly forbidden. So I suppose the question is there any evidence out there of someone who came without safe conduct and contrary to the laws of the realm who was considered under the sovereign's protection? The closest I know is the gypsy example from the reign of Queen Elizabeth, but even that's a reversible reference, right? They say scruples and doubts have arisen. What do we do with these individuals who are born in the realm to gypsy parents? And they said, well, in this case, it reads like a legislative decision that we're not going to make them leave the realm. Sounds like it could go either way. And I'm getting the signal. Thank you for your indulgence.
Keith, thanks so much for your paper and for spending so much time of it on Ilan and my New York Times op-ed. If I had it to do over, I would not have used the word amity in the sentence in which we were distinguishing illegal immigrants from enemy aliens. I would have not used the word amity. I take that word back. But I want to focus on your conception of subject to the jurisdiction thereof. You agree, I think we agree, focusing on what we agree on first. You agree, we agree, that the debate is about the original meaning of the term subject to the jurisdiction thereof. And you agree that this meaning is not reducible to the children of the three classes of aliens, and only those three classes that were discussed at the time. You agree that in principle, whatever the original meaning of that was, it might also include children born to aliens that were not in those three classes, depending on that meaning. So I'm trying to understand your conception of subject to the jurisdiction, and I have two hypotheticals about your formulation that might help me understand it better. Now, when it comes to Native Americans and invading armies, you say, quote, the land is doing the important work, by which you mean control of or governance of the land. In particular, you say that Indian land is within the territory of the United States, but not governed by the United States. Likewise, children born to parents in armies occupying U.S. territory that is not governed by the United States are not natural-born citizens. So on your theory, what about the children born to parents who were living in the Confederate States of America during the Civil War, which was U.S. territory, not governed by the U.S.? Were they not considered natural-born citizens, or should Congress have made these children citizens by statute? Second hypothetical. At the end of your paper, to sever the status of children from that of their parents, you ask whether you can murder the child of an illegal alien with impunity, or ask for the immigration status of the parents before rendering an infant protection from abuse. But doesn't this argument prove too much? you acknowledge diplomats are outside the full jurisdiction of the U.S. So on your theory, can the children of ambassadors be murdered with impunity? And would we ask the diplomatic status of the parents before rendering assistance to an abused infant?
Well, thanks a lot. Thanks for this paper, Keith. I agree with a lot of it. And we welcome you over to the camp of applied originalism. But nonetheless, I'm going to ask a theory question. But to make up for that, I'm going to ask an applied question to Tom, and I'm going to try to do both of those very quickly. So, Keith, my question is about the children of people not lawfully present. Let's assume that that, in fact, is a category that didn't exist at the time that the 14th Amendment was ratified. There's been some pushback on that question, but I think that generally we can agree that the framers just didn't recognize that as a category. So reading the amendment the way you do, and the way generally that I do, results in it deciding a very important question of public policy today in a way that's really accidental, in the sense that they could have written it in a different way and accomplished the same thing that they were trying to accomplish. And it might have just happened that that different formulation would have excluded the children of people not lawfully present. Does this pose any kind of a problem for originalism, or for certain types of originalism, that might depend on the wisdom of the framers or the wisdom of the process, or indeed anything about having important questions of policy determined by decisions of the past, when in here we're looking at a situation where there really was no decision. It's just an accident that the language has the result that you and I think that it does. All right, now my question for Tom is, so I think all this about, as you know, I think all this about international law and General Halleck and all that stuff is all super interesting. But does it ultimately matter if we're trying to make sense of what I think is clear constitutional language, in the sense that we're not talking about what was the rule for citizenship prior to the amendment. But we're asking what was the rule for jurisdiction, because that's the rule they picked for citizenship. So just to take your point about the consuls, which is that I see why that's tricky, but actually, if you think of it in terms of who has a right to citizenship, but if you think of it as who has a right to jurisdiction, my understanding is that actually I think that isn't tricky, because my understanding is that, and maybe just assume I'm right here, that consuls did not enjoy ambassadorial immunity. They had different status because they were commercial agents rather than diplomatic agents. And if that's true, then regardless of what the international debate over the proper citizenship of the children of consuls was, the constitutional rule is quite clear, because they were, in fact, subject to jurisdiction. Because they didn't have diplomatic immunity, and therefore the Constitution actually answers the question, and we don't need to worry about what General Halleck said.
You know, it turns out subject to the jurisdiction, and I read it to mean not immune from the jurisdiction of the United States under international law, right? And so some people thought consuls were actually immune if they were alien consuls, not the U.S. citizen consuls for China, right? And so that was debated. And so if you read that in that sense, and I think this is partly the answer to Randy's question too. And persons born or naturalized in the United States and not subject and not immune from the criminal civil jurisdiction of the United States. Well, I mean, the Civil War, whatever you think about the Confederate States, they're still the United States, right? A very tricky question, which is in the Inglis versus Snuggs Harbor case, is what about if you were born in New York when it was occupied by the British after the Declaration of Independence? And you know, in Inglis Harbor, they kind of wave their hands and they're saying, you know, we're not absolutely sure. And the last one point in response to Elon, safe conduct was not an explicit document. I actually wrote an article in 2006 called The Safe Conduct Theory of the Alien Tort Statute, which you very kindly cited. So Blackstone, in his treatise, mentions something called the general implied safe conduct. So, and he says that basically any country with which you are at peace is subject to a general implied safe conduct. Well, that's everybody in 1783 for the United States, right? So I'm kind of with Keith on this because safe conduct wasn't a document. Like Blackstone had diluted it to something he called the general implied safe conduct. And when I read that, I was like, what the heck is that? And then I realized it means that it's sort of a default rule that everybody from a friendly or neutral country is entitled to safe conduct. About any statements on temporary sojourners, the case, and Keith, to his credit, talks about it a lot, is Lynch versus Clark, 1844 Chancery Court opinion, very important opinion. The facts are fascinating, and it's an equity opinion, so it's not a common law opinion. And what happened was you have an Irish guy down on his luck, his brother strikes it rich in New York, comes over, stays for 4 years, hates it, misses home. This is right before the Great Famine, decides to go back, and he goes back 3 months after his daughter is born. And the chancellor raises his hand and says, look, was he intending to stay here or not? I don't care. He was here. It's fine. But factually, it was kind of a residence kind of situation. And the reality was Lynch versus Clark was the one that sort of tipped me off to this theory, because then you see all these stories of people who come over, go back, come over, go back, right? And that's happening a lot more in this period through to Wonka Marx. Sorry, that was a little bit longer than I needed to take.
So I'm just a parochial American, and I don't care about law of nations and international law. So I care about British common law to the extent it gets accepted into American law. Otherwise, I don't care about that either. So you know, there's that. And again, I don't think that the law of nations or international law is doing much work in terms of how they're arguing or thinking about the drafting of the 14th Amendment, particularly in the kind of rule they're trying to embody there. Although, you know, I think it does overlap in lots of ways. They're probably interesting and fascinating about how it plays out in some of the details. So I'm totally in agreement about the safe passaging. I think that's just an anachronism that has no particular relevance to the way in which this doctrine is being played out in England, let alone how it winds up being carried out into the United States. To the extent that these things matter, they wind up eventually only mattering in the context of enemy aliens, and that's not what we're talking about. And so I just don't think it creates any kind of broad rules one way or another about this, except the way we might think of it is through this sort of implied safe passage doctrine that winds up emerging eventually. I think, you know, as of course, in the way, as you say, the paper is all about sort of by birth alone. It's a nice little phrase somebody uses, and so I borrow it for the title. I use it in a couple places. I don't actually just say birth alone throughout the paper. Instead, the point is precisely that it matters the circumstances under which you're born, which is to say you have to be born in the territory, you have to be born under the governing authority. And if you're born under those two things, then that's it, you're done. You're an American. Congratulations. The alternative, though, that's very significant that was emerging out of pro-slavery arguments leading up to the Civil War and that they were very concerned with rejecting was precisely that birth under those circumstances was not going to be sufficient to make you an American. You also not only had to be white, but in addition, it was a political decision as to whether or not we wanted you. And if we didn't want you, Southern slaveholders argued, we could deny you citizenship, even if you were born under those circumstances. And so the core question that the 14th Amendment was attempting to adopt in part was, are we going to leave that at the continuing political discretion of current politicians, or are we going to shut that door? And the answer was, we're shutting that door. It's not going to be a political question as to whether or not you're going to be recognized as a citizenship. It's a question of, are you born under these circumstances, the traditional common law circumstances? So about the Confederate States thing, I think the Confederate States are kind of fascinating and interesting from this perspective. And of course, the Union is waffling about how they want to think about the Confederate States, and so it creates lots of complications for them, including on whether or not you can charge Jeff Davis as a traitor, but also in this kind of context. And so the doctrine of the that the Union winds up adopting probably doesn't allow them to extend this logic to children born under the Confederate States. But moreover, there are very interesting questions about how even the English common law, as it had been developing in English context, thought about governed territory in this kind of context. And so the traditional exception, as they characterized it, is if you are a child born of the invading army that occupies, sometimes gets characterized as if you occupy a fort by surprise, because how else could the English lose a fort, and you're born under those circumstances, you're not a natural born subject. Well, that raises questions about, okay, well, what if you're not the invading soldier? What if you are just one of the civilians in that occupied territory? And you were a loyal Englishman. You're now having children within that occupied territory. What happens to your children? And it turns out the English weren't very clear about this at all as to how they're thinking about it. But eventually they wind up sort of adopting a rule that suggests that if you're only being temporarily held under those circumstances, your children are in fact natural-born subjects of the English Queen. So when the English reoccupy the territory, all your children are going to be recognized as natural-born under those subjects. At the same time, though, they also emphasized, but by the way, you can't kill the sovereign that is currently recognized, so they want to carve out a de facto sovereign rule in order to discourage political assassinations under those circumstances by freelancers. So they've got a weird doctrine that they sort of developed to try to deal with it, but it is one of these weird, interesting edge cases about how do you think about these kind of circumstances, and it's part of what complicates the American context, right? It's the American context of the Revolution, sort of a temporary occupation in this sense, or is it something else? And the British wind up having to cover their butts by eventually signing some treaties and admitting we're actually an independent nation and we're not loyal to them anymore. I am fascinated by the question, the theory question about what if you accidentally cover important policies for the future. It might be a good reason to not be an originalist, to be a living constitutionalist. It doesn't bother me. It's like that happens with written constitutions as part of the risk you bear by writing constitutions, and that will sometimes happen. I'm willing to live with that. And if we don't like it, we should rewrite the text.
Can I have a quick clarification? Yeah, Justice Thomas's opinion in Inglis dealt with the situation where a kid is born in British-occupied New York, and the father is a loyalist between those years. And Thompson essentially says you're not a citizen of the United States. Is sort of where he comes down on that. I mean, it's a fascinating issue, and they really doubled down on the idea. And the international law is fascinating because the British had actually recognized unilateral collective naturalization when they recognized the Dutch republics from Spain, and then they flipped when it was their own colonies, and they said, like, oh, it has to be reciprocal. You can't unilaterally become citizens of a separate entity.
Terrific paper, Keith, and thanks, Tom, for your comments. I want to float an intuition, ask you guys to comment on an idea I've been thinking about that relates to the Barbara litigation and all of this discussion about subjects to the jurisdiction thereof and sojourners and citizenship. And the basic intuition is that if we actually try to put ourselves in the frame of mind of the framers of the 14th Amendment, they did think a lot about sojourners, I want to suggest. They thought a lot about jurisdiction, and they thought a lot about those things in two contexts that we haven't been talking about a lot, which is state citizenship and slavery. So I think it's a mistake for starters to think that that group did not think a lot about sojourners because they were intimately familiar with the whole history of slave transit cases that actually had a big generative effect on the run-up to the Civil War. So in cases like Commonwealth versus Aves, famous case decided by Lemuel Shaw, one way to describe the case is that Shaw held that a mere sojourner in Massachusetts, a slaveholder from Louisiana, was subject to the jurisdiction of Massachusetts, as was the 5-year-old enslaved child. Even though, for example, the slaveholder argued in that case, and Benjamin Curtis was the attorney, incidentally, I'm domiciled in Louisiana, I'm not domiciled in Massachusetts. Shaw brushed that argument aside and extended the jurisdiction of Massachusetts to the child, and therefore the child was freed. So it's an exercise, I would call it, of political jurisdiction and sovereignty. People versus Lemon, this other case, right? There's a Virginia slaveholding family in the mid-1850s, running up to 1860, traveling to Louisiana, but they pass through New York. New York, a free state, says, you may only be here for 2 days or 3 days or whatever, waiting to catch the next ship, but as far as we're concerned, you're subject to the jurisdiction of New York. Again, the claim is made, I'm not domiciled in New York, we're not domiciled, we're just passing through and so forth. But when it came to exercising jurisdiction at the state level, that's how the northern free states thought of it. And then a really interesting case, it's actually from much earlier, it's called Commonwealth versus Holloway. This is a Pennsylvania case, 1816. A fugitive slave, a woman who escapes into Pennsylvania, gives birth in Pennsylvania. And the question is the child born free? And under Pennsylvania law, a citizen of Pennsylvania, because those things basically went hand in hand. And the court in that case says yes. Again, no domicile, sojourner, but jurisdiction attaches, it applies. Citizenship in that case followed. And I just think if we ask, what did the framers, who are, in 1866, entirely from these free northern jurisdictions for the most part, I guess there's some border state representatives as well, but essentially these are the battles they had been fighting all along. And they had been vindicating over and over again the primacy of state jurisdiction and the way it attached to even sojourners, right? And there's a whole bunch of case law in this area. I'll stop with the last observation. I'm a little surprised that we're not talking about the 13th Amendment, because the 13th Amendment, by its terms, refers to slavery being prohibited in the United States or any place subject to their jurisdiction. And again, I want to suggest, surely that applied to sojourners. So if a Brazilian slaveholder were to travel to the US territories, let's say, and brought slaves with them, they would be subject to the jurisdiction, and a child born to an enslaved person would be freed, and a citizen, presumably. So just wanted to suggest that that's another way to think about all of this and ask for your thoughts on that.
All right, well, actually, Roger Smith was my senior advisor in history at Yale, so all three of us are disciples of Roger Smith in some way. We may also be disciples in the sense that I think all three of us agree with essentially, Keith, your view that the conventional or traditional view of the Citizenship Clause is the better one as opposed to the revisionist view. But let me ask you, Keith, as I read the article, it proceeds in mostly three parts. One is the premise that the Citizenship Clause declares or embodies or reaffirms or constitutionalizes, for the most part, the English common law. That's sort of a premise. It then proceeds to describe and explain that common law and what it means, and then in the final part applies those lessons to the example of children here, children of those unlawfully present in the country. I think I'm persuaded by both of the second parts, and those are the parts that you're mostly devoted to in the paper. But I actually found the evidence on the first part thinner than I expected. So, for example, I'm wondering whether it's clear that the drafters and ratifiers really thought that they were embodying the English common law. I noticed at one point in the paper, say at page 16, you talk about Kent and the commentaries on American law, and you note that that edition, the 1860 edition, would have been in the hands of the drafters of the 14th Amendment. And I'm just wondering whether there's more evidence that there was a direct influence here than that it might have been in their libraries and they might have read it and relied on it in the drafting. And those sorts of concerns, I guess you could say, are magnified by what I read in your description of the common law. So a lot of the common law seems to be devoted to these issues of allegiance and obedience. I don't see any of that in the language of the Citizenship Clause. It just says subject to the jurisdiction thereof. That seems like a more liberal phrasing of the qualification for citizenship for those who are born here, more generous than is reflected in the English common law. So maybe they were expanding the English common law. Maybe they wanted, after the Civil War, a more generous understanding than was present in the common law, and maybe even more generous than in the 1866 Civil Rights Act, which said something like, if you're born here and you don't have allegiance or protection from any other government, it's even, the Citizenship Clause is even broader than that. So maybe we ought to read, as John suggested, we ought to read the language of the Citizenship Clause in light of the more liberatory thrust of the post-Civil War amendments. And so maybe you've taken on too much of a burden, Keith. You've persuaded us, but you didn't have to persuade us so much.
My question is a little bit to the side of the thesis of the paper, but it's just about the meaning of citizenship. It seems that in the antebellum debates, the side of the South kind of argued for this thicker, more substantive, more Republican idea of citizenship, and the side of perhaps the 14th Amendment just sort of rejected that out of hand and chose instead this, well, citizen is just the label for the people who live in a democracy or a republic, so we're not going to call them subjects because that would be bizarre, but really we're talking about subjects. Do you think that that's, how far do you think that that could be pushed linguistically to be true? Do you think they thought of those two things as totally separate ideas? Or do you think that they saw them more on a sort of spectrum where you start out as a British subject and then there's kind of a gradation up to a Republican citizen? Or did this, not occur?
Yeah, so I think the subject-citizen shift is an interesting one. I think there are potentially interesting little wrinkles there that are potentially worth exploring. I think in general, the way they're imagining this working at the time of the founding and the revolutionary period is they just sort of change the terms and don't really think through very much the implications. The specific point, though, relative to citizenship is that there's this very touchy issue that the framers of the 14th Amendment are trying to duck a little bit, but it has real implications for getting around sort of these earlier antebellum debates, which is to what degree, once you call somebody a citizen, are you also saying they have the franchise? And is that the crucial move to be from a monarchy to a republic? The shift from subject to citizen language means you're moving from the people that are governed by this system to people who are the governors of the system. And so once you award citizenship, does voting come with it? And the North becomes very concerned, Northerners all through the antebellum period become very concerned with saying, no, these things are separable. That doesn't follow. And the 14th Amendment drafters are still waffling on that and trying to duck that issue a little bit, and so because they're not yet ready to do the 15th Amendment at that point, or at least they don't have a big enough majority willing to do it, and so it's something they're obscuring a little bit and trying to separate out those two things in particular. It is true, I think in hindsight, that I probably should have spent more time thinking about this first component of the paper, really about sort of to what degree is the 14th Amendment just declaring the common law as opposed to revising it in some significant way, rejecting it in some significant way. For example, in part, I think that's the burden of part of Kurt Lasch's argument, for example, is really to suggest that pay no attention to the common law. It's all about what happened in these little debates that occurred across 5 pages of the Congressional Globe because they were rejecting everything before that. I think if I was doing a better job of responding to that kind of concern, it would really require saying more about the extent to which this is true, and the paper just doesn't do that enough. I think it's still true, but I could have spent more time on it in the paper and marshaled more evidence on this particular point. The sojourner point I like a lot, this idea about the sort of, because you're totally right, there is a different sojourner debate that's very robust, very politically salient, that matters for these kinds of issues that was occurring in the North in particular. Well, not just in the North, but it had a lot of, it was being played out in Northern courts in particular. And I had not really thought about the extent to which that logic may have implications in this kind of context. They didn't talk about that, particularly when they're drafting the 14th Amendment, but you can totally imagine unpacking a theory specifically about temporary sojourners that would take advantage of that and say this is part of the abolitionist Republican theory that is implicit in the 14th Amendment at the time. I'd have to think through how much I think that's necessarily carries through. It's consistent with what the Lynch decision winds up saying effectively. It just applies it in different contexts, but it gives you a lot more cases to work with and a lot more ways in which they're talking about it. So I like that as a potentially different paper, and maybe I'll do it. Because certainly all that material, I know all that material. It's all part of the supplemental stuff we've generated for the casebook that I've done with Mark Graber and Howard Gilman. So it's all part of materials I work with, but I hadn't thought about it in this context.
So on the sojourner point, I think, John, the draft I presented at Wisconsin talked about this issue, right? And you're right. I mean, the sojourner issue is fascinating, and I cite these cases. So what happens is Southerner wants to go north, moves domicile, and the rule is enslaved persons actually did not have independent domicile, so the idea was the domicile transferred with the owner. And then the northern states started coming up, so then it's like the Confederates, okay, I'm not going to relocate to the north, but I got relatives I have to visit, so they start visiting, and then these northern states start saying, well, even if you sojourn, by operation of law, the enslaved person's status shifts. And I talk about all this, and so sojourner is on the radar, but domestic sojourner is very different from international sojourner. And I think because the citizenship clause, you're all within the closed U.S. system. So if you create sojourner citizenship issues in the international system, you're creating foreign controversies with Germany, Great Britain, China, those countries. You're not operating within the closed system of the United States. So I think the sojourner issue was on their radar, but as or naturalized suggests, because or naturalized is a flag for a foreign-born person, they would not have come to the same conclusion as to international sojourners as they would to domestic sojourners. Now, Lynch versus Clark is a hugely significant case because that is an international sojourner, so I have to deal with that. But I think that, and I'm very upfront in the draft, right? Like, there was this domestic sojourner issue, but I think it's different from the citizenship clause. With regards to Dale's point about how much the 39th Congress actually would have looked at common law, I am convinced Gray writes a magisterial opinion in Wonkimark that covers everything, and he creates this account of how indebted we are to the common law. I think that's entirely manufactured as a matter of what the 39th Congress and people in 1868 thought. They hated Britain. They rejected the other two rules. The very same Congress that ratified the 14th Amendment ratified the Expatriation Act, where they say, unlike those bad old countries, we don't believe in perpetual alliance, right? So I think that basically, I think that there was actually a much more profound rejection of English common law of subjectship but anyways, and then 1898, circumstances change, and Gray crafts this sort of compelling narrative, which is fake in terms of what was going on in 1860. Sorry.
A brief question, or I guess comment more, going to the constraining power of originalism that we've been talking about in this conference. That, Keith, I take your conclusion of the paper as kind of both a plea and a celebration of originalism, that the Constitution protects certain rights and takes them away from the whims of future Democratic majorities, and by committing ourselves to originalism in this instance, we can ensure that the Constitution is followed. But there are right now sophisticated bodies of originalist literature on both sides of this issue, written by people in this room and leading originalist scholars. And when the Supreme Court decides this case later this term, a justice can cite a great deal of originalist literature, whether it's your article or others, in support of either conclusion. And I'm going to go out and predict that there are certain justices who will be citing the revisionist literature in order to say that it turns out that, happily, the original meaning of the Constitution, once again, shockingly, just happens to support their preferred political view here and that of the sitting president of the United States. And so I guess my observation is, one wonders whether, simply given the nature of our Constitution, given the nature of the legal academy, and given the nature of the legal enterprise, the recent move of the Roberts Court to adopt originalism has really not done anything to prevent our Supreme Court justices from at least subconsciously deciding cases on the basis of their own preferred political preferences.
Thank you. Okay. Tom, very small point. I'm not sure I see how you can agree with Keith about illegal aliens and then disagree about temporary sojourners, because illegal aliens lack the legal capacity to establish residence here, and a classic common law rule is that if by operation of law you're forbidden from establishing residency somewhere, then you can't become a resident, even if you in fact live there for a very long time. Keith, I guess my question for you, I think you're right about the executive order, but I wonder what you think about Congress. So could Congress pass legislation that changed the jurisdictional status of aliens, say aliens who are illegally present here, and what would it have to look like? Could they, for instance, say, in general, they will not be subject to criminal prosecution under federal and state law, but if caught, they'll be promptly rendered back to the place they came from, giving them a status more like diplomats? Would that be enough to make them not subject to our jurisdiction? If that's not enough, what would be enough?
Sort of adding to that for both Keith and Tom, in determining whether somebody is subject to the jurisdiction or the governing authority of the United States, does it matter about the extent to which the U.S. has exerted its authority extraterritorially? Like when the United States says some people born in the United States, if they're drafted by another country, will get the diplomatic protection of the United States, and some people won't, like if they're drafted by the country of their parents' nationality at the time they were born. Does the extraterritorial authority matter?
So look, I'm a political scientist when it comes to thinking about the court, and so I don't trust them at all. And so I totally buy the idea that these things require effort in order to make the lock-in work. I mean, text and history helps, but it's not the whole ball game. To be sure, people have to write papers and stuff. I don't quite know. I haven't thought through enough, I think, on the could Congress do it question. It would make Rogers happy if I were to say that Congress can, and he would say that I've committed myself to thinking that's probably true, because and other things I've written about Reconstruction. So I think you might be able to draft a statute that would go a long way toward doing some of that work, actually. But exactly how you'd write it and what exactly the implications would be, I'm not entirely sure. But I wouldn't rule out the possibility there's some space there for Congress to try to carve out more things like Native American tribes that they would regard as sort of outside the subject of the United States. I just think it'd be probably tricky to do in the context of the kinds of situation that undocumented aliens are in.
So, Will, on your question, so the government has focused on this concept of domicile, and they understand that you can't establish domicile without the government's permission. That's actually not an accurate statement of domicile, and I originally actually started with the domicile because domicile was not a governing authorization. It was, as an international lawyer knows instinctively, it's a conflict of law concept within, and it originated in the Roman Empire. So you had citizenship in the Roman Empire. Within the Roman Empire, you had to determine internal municipal status for various aspects of local taxation and so forth. There's language in Wong-Kim-Ark that suggests that you need the government's permission to establish domicile, but that's actually erroneous as a matter of contemporaneous law of nations. The backup to that backup is that, I started thinking domicile, but based on the language, I think it's just residency. So domicile was a two-part test. One was considered the fact of residence, and there's actually some wiggle room on that. And the second was this intent to get domicile. And so I'm suggesting the intent thing was washed out, and it was a really complicated inquiry. And so I don't, the government has its understanding of what domicile means.
Why is the subject to the jurisdiction thereof not the same as the Civil Rights Act of 1866, not subject to any foreign power? Like, how do you reconcile those? The Civil Rights Act of 1866, I guess, is not unconstitutional under the 14th Amendment. And why would a criminal alien not be subject to a foreign power? If they're caught and they're illegal, they're deported and sent to a foreign power. And then why doesn't the violation of immigration laws put the criminal immigrant outside of the local allegiance? And even if they could be punished under our laws, they still wouldn't be subject to that local allegiance and would be subject to that foreign power the same way that like a Native American could commit a crime on American soil, and be punished, but not have the birthright citizenship.
There are two separate issues about the deportability of an undocumented alien versus the question of criminal liability, for example, committing crimes inside the United States. And we would claim both for people in those situations. If you commit a local crime, you're subject to local criminal law, and then we also are claiming that we can deport you. And it's the claim about the first one that particularly focuses our attention on you're subject to our jurisdiction as long as you're in the country for those kind of purposes, even though our hope is to get you out of that jurisdiction as soon as possible. And we claim the authority to be able to do that.
So just a very quick question. I didn't think I saw it in the paper. I apologize if it was. On the Native American, one of the ways you characterize the Native American exception is that they are within their own sovereign territory. My understanding of the history, having spent a little time but not enough, so I'm just asking, is that children of Native American were not citizens except for maybe by statute, even when they were born off the reservation, as long as they've maintained members of the tribe. And that, to me, seems to undermine the whole explanation of the Native American exception that you give in the paper.
Yeah, so they wind up making distinctions between some who are on reservations, some that are on sort of these quasi-independent status, and the language varies as to what people prefer about how to characterize these sorts of self-governing tribal areas, as opposed to what they would have characterized at the time as assimilated Native Americans who were living as part of the larger body of the Americans more generally. And those they would have regarded as subject to the jurisdiction as the ones who are outside, operating within their own semi-sovereign capacity, that they would say. So it depends on sort of which tribal relation you're in. Are you with the tribe beyond American governing authority, or have you left the tribe and are operating inside American territory and assimilated into larger population?
Let's thank our panel.